Okay, you may proceed.
Your Honors, I am Christopher A. Berman. I am representing myself pro se, so I will refer to myself in the first person.
Okay.
I would like to reserve 3 minutes at the end for rebuttal.
Okay, when you're into your 3 minutes, the light will turn yellow on the podium there. So, okay.
Thank you, Your Honors. Your Honor, I am here on a matter of a case that I had brought against Penny K. Every and her employer for notary fraud under Florida State Statute 117.05. The case was heard, the case was in lower trial court in St. Johns County. The defendants made a motion to dismiss based on statute of limitations, which is under 95.113. They prevailed on the statute of limitations. I argued that the case...
There's no evidence here. I mean, the statute begins to run when you discover or through the exercise of due diligence would have discovered facts giving rise to the fraud claim. Is there any evidence that there was any kind of attempt to cover up? For example, the documents that were available online or through the public record were the wrong documents so that you couldn't find them or were not, anything like that?
Your Honor, my position on this, and the reason that I had argued for 95.0312A, where an action for fraud must begin within 12 years of the date of the commission of the fraud, is that...
well, that's a statute of repose. In other words, even if you never discovered and never could have discovered it, it ends after 12 years. But the general statute of limitations is shorter than that. And it begins to run when it should have been discovered based on due diligence.
I understand, Your Honor, but I bring into account the idea of scienter, of deliberate cover-up and fraud of a...
and that's what I'm questioning. I mean, if the documents are readily available online or by a simple check in the public record, I mean, it's hard to see how someone couldn't have discovered that with the exercise of due diligence. In other words, the argument is, I didn't know what stock I had, but Your Honor, easily could have checked and found, and that doesn't sound like due diligence, really.
Well, Your Honor, I can address that matter in the fact that when I had originally incorporated my company with the non-party to this case, Mr. Kafka, I was told that the paperwork was being sent up to his accountant, that it would be taken care of. I unfortunately did not put a lot of effort, or perhaps I was too trusting nature. I never knew that the documents had been notarized and was unaware of the...
Mr. Berman, were the articles that ultimately were filed that, had one-third instead of 50, were they the same ones that you signed? In other words, had you signed it and then Mr. Kafka changed it? Is that what happened?
That is my contention, Your Honor.
And is your signature on there?
Yeah, my signature was on it. We signed, I met with the third party, the non-party, Mr. Kafka, sometime in July, and signed that document with him only. There were only 2 lines on that document.
But so they changed Mr. Kafka, I guess, changed the terms internal of the document and added his wife's signature?
That is my contention, and brought it to a notary that
so you don't dispute that's not your that is your signature on the document?
That is my signature.
Okay.
However, I have incontrovertible evidence that on the date that the articles of incorporation...
Why wouldn't you sue Mr. Kafka? He's the one that seems to have defrauded you. How does the notary acknowledgement do anything? I mean, the
notary acknowledgement started the process. The notary fraud deprived me of ownership in my corporation.
How's that?
And, Your Honor, I did sue. I have a case against Mr. Kafka in U.S. District Court for fraud.
Okay.
This is a standalone case because this is the proximate cause of the issue. I was never aware that the articles of incorporation...
So you think that you weren't there, but it is your signature.
My signature, but I was never there when it was notarized.
How does the fact the notary, acknowledge that you were there and signed it, somehow you get damages for that? I mean, you did sign it.
Your
There's
Honor,
no dispute, you signed it.
Your Honor, there are cases that have been judged in Florida courts. One of them resulted in an award of $300,000 for a similar case to this that happened in a bank where it was between a husband and wife. I believe it was the wife brought the paperwork to a notary that she was friendly disposed to, and this was notarized without the husband being present. The wife then took advantage of that to improperly obtain the property that was joint property to her and her husband. The proximate cause of the problem or the issue is the fraudulent or the misconduct of the notary, which led to the ongoing issues. So, and that's why I brought the case in the first place. What I wanted to allude to, or what I wanted to state here, is that in researching this, I find a number of cases where the doctrine of delayed discovery has been approved, specifically Jolly versus Eli Lilly. Now, this was a California case, but it reads, the statute of limitations begins to run when the plaintiff suspects or should suspect that his or her injury was caused by wrongdoing, that someone has done something wrong to him or her. Then I want to cite specifically...
Did you ever get your stock certificates? When did you get your stock certificates?
Your Honor, I was never provided with my stock certificates, but I was provided with a number of excuses. Wouldn't
that have alerted you that perhaps maybe there was something wrong? And when you didn't get your stock certificates, your stock certificates would have told you exactly what your interest was in the company.
Your Honor,
when you get your stock certificates, didn't that alert you to the fact that perhaps there was something wrong and to investigate and go find out?
Your Honor, there are mitigating circumstances in 2006, which was a year after the company had been incorporated. I was riding a bicycle. I was struck by an SUV. I have resulted in 4 fractured vertebrae. I was in a period of recuperation. The last thing I was thinking of at the time was looking into this, although my accountant did call Mr. Kafka's accountant. His accountant promised that these certificates, the K1s, would be forthcoming. They were never forthcoming. I was in a serious amount of pain. I was not concentrating directly on this matter. It did not come to light until I began a thorough investigation.
When did you get your stock certificate? Did you ever get your stock certificate?
I was never provided with my stock certificates. I was provided with excuses.
A 4-year period of time went by and you never got your stock certificates, although you were injured. I understand that, and I'm sorry to hear that. But that didn't alert you to investigate even before you're injured or after you recovered?
Your Honor, one puts a significant amount of invests psychological capital in a relationship with a business partner. I was perhaps the same way one invests in a relationship with a marriage partner. The expression is, why is the husband always the last to know? Because the husband has an investment in believing that the wife is telling him the truth, or vice versa. I would like to say, and the reason that I cite a particular Supreme Court case, which was decided in April 2010, which was Merck and Company v. Reynolds, affirmed extended discovery. And Merck, which is a pharmaceutical company, this was for securities fraud. The statute of limitations for securities fraud was 2 years. Merck argued that Reynolds and the investors should have known, using due diligence, that there was an issue with the securities. They never denied that the securities fraud didn't happen.
Do you think that you had a duty of due diligence in this case to?
Your Honor, one can only have due diligence if one knows that something is actually out there and suspected.
But when you didn't get your stock certificates, maybe that could have alerted, some people that there was something wrong. But all these papers were filed; they were matter of public record. You could have checked the public records to see, rather easily, I think, to see what your interest was and whether anything had been altered. Right? You could have done that.
I understand that, but I was naive in this process, Your Honor, and I would like to say that what the Supreme Court cited in the case of Merck, United States Supreme Court cited in Merck versus Reynolds, what Reynolds' defense was that the investors should have known through due diligence that there was a problem with the drug Vioxx, because they said it was on CNN, it was on 60 Minutes, it was in the New York Times, it was in magazines, that there was a problem with the drug Vioxx that would affect the value of their stock. It was out there. Yet the Supreme Court ruled that this did not constitute a lack of due diligence when there was deliberate cover-up and deliberate fraud, and there was an underlying criminal action that was involved with securities fraud. In this case, the underlying criminal action in notary fraud is a third-degree felony. The decision that was rendered by Justice Breyer basically concluded that a case of deliberate fraud for those committing the fraud would only have to be successful in concealing the fraud until the statute of limitations or the tolling period for the statute of limitations had expired. Then the author of the fraud would be safe from any legal repercussions. So I argue the fact that that in this case, I'm asking the appeals court to follow the form of the United States Supreme Court in their decision for delayed discovery for in Merck v. Reynolds, and to remand the case back to the lower trial court for further proceedings. It was under review by Justice by the Honorable Judge Traynor.
Even in the Merck, now you understand that Merck is applying a federal statute of limitations, and we have to apply the Florida fraud statute of limitations. So those are two different things. We can't tell Florida trial judges to ignore Florida law and go follow a federal statute when they're applying that Florida statute. But even still, I mean, the Merck case, under the federal discovery rule, the statute begins to run when a plaintiff knew or through reasonable diligence should have known.
Well, the statute in Merck was the initial statute that Merck had cited was the fact that there was the statute of limitations ran from 2 years from the date of the beginning of the securities fraud, which they never denied that the securities fraud had happened. They simply said that, 2 years is up, we're off the hook because they didn't do due diligence.
But under the federal discovery rule, it's 2 years from the date that they knew or they reasonably should have known. This is very similar to the due diligence requirement in the
I understand. Yet the Supreme Court ruled that that was not correct, that the way the case was finally judged was that the tolling period would then begin from when the investors investigated it and became aware of the securities fraud, which was, I believe, was a year and a half or perhaps 2 years after the end of the statute of limitations. So the United States Supreme Court said that where there is scientor, where there is deliberate fraud, where there's collusion to commit a fraud, that this invalidates fixed sets of statute of limitations that allows for delayed discovery and for taking the
And I guess that's why I was asking at the beginning whether there was any evidence that the documents readily available in the public record were altered in some way that they would have concealed what you say was the fraud. And I thought the answer was no, that those, if you looked at those documents, you would have found.
If I had known those documents were in the public record, I was told originally setting this up and going into business with my partner, Mr. Kafka, that the documents were being sent to his accountant in Pennsylvania, that his accountant was taking care of incorporating. This was new to me. I liked this individual when I met him, and I felt I could put my faith and trust in him. It was actually Judge Traynor who had looked at this case, and he actually looked at it in two different ways. He said, if I can recall correctly, he said, if I rule for you, meaning the plaintiff, he said, the defendants will appeal it. If I rule for the defendants, he said, you will appeal it. I believe he was putting the ball back in your court in order to come to some sort of resolution on it. And perhaps for me, he saw it as an intelligence test. I'm not exactly sure, but I do wish to, and I see that I'm running down on my time here, so I want to leave time for rebuttal. But it is my contention that generally form follows function, that Supreme Court decisions are taken as precedent for state decisions. There is a provision for delayed discovery in Florida statutes, and in seeking justice for what has been done to me, I would ask the court to remand the case to the lower trial court for further proceedings. Thank you.
Thank you, Mr. Moore.
Morning. May it please the court. This matter is before the court on an order dismissing an action with prejudice on the basis of the statute of limitations. Standard review is de novo, and this court, like the trial court, is confined to the four corners of the complaint. I respectfully submit that the trial court correctly dismissed the complaint with prejudice, not to test appellant's intelligence, as he suggests, but because he was following the law. And if you look at the complaint, one of the first facts that stands out to me when I read the complaint is that appellant alleged that he's never met this notary public that committed fraud on him. The elements of fraud include false statement, reliance, things of that nature, and there were no statements ever made by the notary public to appellant, nothing that he ever relied on. Like I said, he had never met her.
That goes to stating a cause of action, doesn't it?
That goes to stating cause of action, but it also goes to tolling the statute of limitations because he makes noises about fraudulent concealment of his cause of action, and he's never met or spoken to the notary public, so she couldn't have been fraudulently concealing his cause of action from him. Whatever anybody else did is irrelevant as far as the cause of action against my clients. And he alleged that in July 2004, he incorporated a business with his co-incorporator and co-business owner. He signed the articles of incorporation. He expected a 50% interest in the business in return. He assumed that his co-incorporator was handling all the paperwork for him, put his trust in him. He described himself as having been naive. Instead, the articles of incorporation were altered before they were filed with the Department of State, and to add a third incorporator, as he's alleged. Now, there's no allegations that would say or suggest how adding a third signature block at the end of an articles of incorporation somehow changed his ownership interest in the corporation from 50% to a third. But I guess for the purposes of giving him all the inferences, we'll just infer that that's what happened. In any event, the issue is the statute of limitations. He waited until 6 years later to, I guess, discover that the signature line had been added to the articles of incorporation, and somehow that tipped him off that his ownership interest had been changed from the outset. And The application of the statute of limitations is apparent on the face of the complaint because nowhere in the complaint does he explain why he waited 6 years to discover that. He doesn't say any facts about why it took that long. He just said 6 years later, upon review of the public records, I discovered it. We start to learn a little bit more about the circumstances that happened between the altering of the Articles of Incorporation and when he discovered it through his briefing. And start off with the law on the statute of limitations. It's 4 years for fraud. It begins to run from the date the action accrues, which coincides with the discovery or duty to discover the alleged fraud. The duty to discover is determined by an objective standard. It means knowledge of facts which would have been discovered in the exercise of due diligence. And we're looking at a reasonably prudent person exercising due diligence. Florida law does not endorse a hear no evil, see no evil approach. And I would respectfully submit that's the approach that appellant has taken and admits to have taken. He was naive. He was trusting. So his argument is that the due diligence requirement should not apply to him, and we should only look at the aspect of when he actually discovered it. Well, that's not the law. The law is either when you discovered it or when in the exercise of due diligence you should have, and whichever occurs earlier. So he completely disregards the second component of that and wants us to focus only on when he actually discovered it. Well, due diligence would have called for him to discover it in July 2004, shortly after the articles were filed. He was a co-incorporator, a co-business owner, and any reasonably prudent business owner and co-incorporator would have looked to see that those articles were filed appropriately and presumably would know the amount of stock he owns from the outset if he's making an investment in a business. Nothing, as Your Honors pointed out, prevented him from finding this sooner. It was in the public records, easily accessible. He alleges in the complaint that he expected the co-incorporator to see to it that it was filed with the Florida Department of State, so he was aware of where these records were. Waiting 6 years is not due diligence. It's just incredulous. It's incredulous that the appellant, 50% owner of the corporation, would wait 6 years. He says he asked for the stock certificate, and he was given excuses instead of the certificate. There's formalities in the statutes that say you're supposed to get your certificate within a reasonable time. If there's no certificates, you're supposed to get written evidence of what your stock certificates would show within a reasonable amount of time. So a reasonably prudent business person would follow these formalities. The fact that he did everything so informally, that smacks in the face of what the reasonably prudent person would do. He seems to be under the impression that the statute of limitations is either 4 years or 12 years, and that the trial court chose 4 years and should have chosen 12. He argues that due diligence is quote, a relative term. And he says in his briefing, he says, there can be no standard for due diligence. Well, that's not Florida law. We look at, it's an objective standard, and it's a reasonably prudent person. So there is a standard for that. He says that there's no reason to suspect anything was wrong over that 6 years, so there'd be no reason for him to exercise due diligence. That's what excuses him from exercising due diligence. But when I went through his reply brief, he put in there all the suspicious things that would give him reason to exercise due diligence. And I'm going to go through those with you, and that's starting with, first off, from the outset, he signed the articles, and then he was told he can't have a copy because the copy machine's broken. Just trust me. Okay? Next, he wasn't provided stock certificates, even though he asked for them. Okay? That's suspicious. He was given excuses as to why he couldn't have them. He didn't receive a 1099 for the year 2004 at all. That would cause me to be concerned about whether or not I even own an interest in the corporation. And then he didn't receive his 1099 for 2005 until August 2006. 2 months, and his injury that he says all of a sudden precludes the application of the reasonably due diligence standard, that happened 2 years after the filing of the Articles of Incorporation. So for 2 years, he buried at least 2 years, he buried his head in the sand with suspicious circumstances in his face, and And he's here today arguing that due diligence shouldn't apply to him. He doesn't allege any misconduct by the notary public, by my clients, as far as what efforts she made to conceal his cause of action. And like I said, in fact, she made none. Everything, as you guys pointed out, or Your Honors, I'm sorry, as Your Honors pointed out, the cause of action is against the co-incorporator, not the notary. How the notary's signature on that document had anything to do with any of this is just beyond me.
You know, our silence is deafening, isn't it?
Yes,
I think you're kind of repeating everything that we already know.
Okay, with that, I'd respectfully submit that the trial court correctly dismissed the complaint with prejudice, and I'd ask you to affirm that ruling.
Thank you very much.
Thank you.
Let me ask you one thing. There's no dispute that Mr. Berman wasn't there when the notary acknowledged. Is that true?
Well, we assume that for the sake of the complaint, because he's alleged it. It's true for the sake of the motion to dismiss.
Right.
Thank you.
Thank you, Your Honor. I'd like to take this time for rebuttal. What I wanted to point out is the relationship that existed within the offices of...
You never saw Miss Every, did you?
I had never seen Miss Every. I was not even...
How could she defraud you if you never saw her?
She defrauded me by signing an altered document.
What she said was that you were there and she saw you sign it, correct?
She said that she knew me personally
Right.
and saw me
She
sign.
acknowledged, in other words,
She acknowledged on a note
before me on this day appeared so-and-so and signed this.
that is a third-degree felony, and that is cause for revocation of a notary's license and a $5,000 fine. The relationship that existed between my client and the employer of the notary is that my client's mother-in-law...
Who's your client?
Excuse me? I'm sorry. That the appellee, let me rephrase that. That the individual who I incorporated with, his mother-in-law is also an employee in the same firm that the notary Penny K. Every works in. So there was a close relationship. The other signatory to the corporate documents is Thomas Kafka's wife. That is her mother who works with the notary Penny K. Every. So there was a close relationship there. This was not some arbitrary notary that this individual went to. This was, I believe, well planned and well calculated. I would like to dispute the fact that I never knew how the articles of corporation were being taken care of. I knew that they were being sent to Pennsylvania. I also knew that my business partner had another business in Pennsylvania, which is still an active corporation called Maitland Imports. I may have been under the impression that the business would have been maybe incorporated in Pennsylvania, maybe incorporated in Florida. I'm not entirely sure, but I put trust in his statements. And I would like to, again, since I have about 25 seconds, return to Merck v. Reynolds that shows the similarities of the two cases. Both cases began with fraudulent acts that had underlying criminal statutes. Both have discovery of fraud after closing of the statute of limitations. Both cite delayed discovery as a reason for the appeal. Both were initially dismissed for lack of due diligence. Both meet the definition of scienter. Both never gave the appellants reason to question documents. Both were argued that the tolling period should begin from the discovery of the fraud and not from an arbitrary statute of limitations. Both argue that deliberate fraud and concealment invalidates a defense of lack of due diligence. The Supreme Court affirmed Merck v. Reynolds, and I'm respectfully asking the appeal court to affirm.
Thank you both very much. Have a good day.